Hello everyone, welcome to IASbaba's Rapid Revision Series for Prelims 2021. This is session 52 and day 72, and the topic we have is the Indian judiciary once again. So these are the hot topics we are going to discuss, that is the alternate dispute resolution, then Law Commission of India, then the rights available only to citizens. So what are the rights that are available only for the citizens? We discuss them. Then Nyaya Bandhu App and the under trials, and then Article 29 and 30, then e-courts, the e-courts project, then All India Judicial Services, and then the Master of Roster of Chief Justices, and Review Petition, Mercy Petition and Curative Petition. So the difference between all these things will be discussed here. Now coming to the first one, alternate dispute resolution. Friends, why was it in news? Because the Law Minister Kiran Rijiju, he spoke about this Arbitration Council of India and the New Delhi International Arbitration Center that has to be set up, and he spoke recently in July 15th. Then, the New Delhi International Arbitration Center Act 2019 was passed in the same year after promulgating an ordinance, and this act provides for establishment of the NDIAC or the New Delhi International Arbitration Center. So, this is an international arbitration center. That is, it deals with the cross-border cases. Then, this act envisages the NDIAC as an institute of national importance. So, friends, national importance means the funding, procurement of land, all those things will be moving in a speedy manner because of this status given. Then, the ordinance seeks to transfer the existing ICADR or the International Center for Alternate Dispute Resolution to the central government. So, this ICADR was running like a corporation with a central government's shareholding, but now almost all the things will be transferred to central government, and central government is the sole onlooker of this ICADR from now on. Then, all the rights, title and interests in the ICADR will be transferred to NDIAC. So, this NDIAC, a statutory body, it will take over everything that is related to ICADR. So, now this NDIAC will be the solo international arbiter, and it will be under the central government. Now, coming to arbitration, mediation and conciliation. Friends, arbitration is a process in which a neutral third party or parties render a decision based on the merits of the case. So, here the important point to be noted is the merit of the case. So, here before arbitration we get to know that yes, someone is committing the wrong and someone is innocent. So, on the basis of that the judgment will be given. Then arbitration renders a binding award. Yes, it is binding. Then coming to mediation, it aims to facilitate the development of a consensual solution by the disputing parties. It is overseen by a non-partisan third party. Yes, friends, here we cannot get to know who is a mistaker and who is innocent. So, a compromise will be made, and it is consensual. That is the decision should be agreed by both the parties. Then, even this is also binding in nature. Then, conciliation, the process by which resolution of dispute is achieved by compromise or voluntary agreement. Yes, friends, even here the voluntary or the consensual agreement is made, that is the compromise is made. Then, in contrast to arbitration, the conciliator does not render a binding award. So, this is not binding. So, conciliation are not binding awards. The parties are free to accept or reject the award rendered. So, these are the differences between arbitration, mediation and reconciliation. Now, come to the next topic, the Law Commission of India. Friends, why was it in news? Because the search for the 22nd Law Commission has been going on and the government is working on it. Now, the Law Commission of India, the facts are the Law Commission is an executive body which is established by the government for a fixed tenure. Then, it acts as an advisory body to the Law Ministry. Yes, it is a staff agent or it is an advisor to Law Ministry. Then, the Law Commission is neither a statutory nor a constitutional body. Yes, as it is an executive body, it is neither statutory nor constitutional. Then, the first Law Commission in India was formed in 1955 with its chairman being the then Attorney General of India, M.C. Setalvad. So, M.C. Setalvad became the chairman of the first Law Commission in India. Then, currently, there is no Law Commission as the tenure of the latest commission, that is the 21st Commission, got over in August 2018. So, now the search is on for the 22nd Law Commission. Then, the members of Law Commission. The commission comprises of legal and judicial experts. So, both the experts are present, and then it consists of one permanent member, one member secretary, two part-time members and two ex officio members. So, 2, 4, 6, 7 and one chairman, 8. So, 8 persons can be comprised in a law commission. Then, the law secretary and the secretary legislative under law ministry are ex officio members. So law secretary overall and the secretary of the legislative wing are ex officio members. Friends, there are several wings in the law ministry, that is the legislative wing, judicial wing, etc. So the secretary of the legislative wing, he will become the ex officio member of law commission. Then come to next, the functions of law commission, that is to conduct legal research and review the existing laws to bring in reforms. So legal reforms are the foremost functions of law commission. Then identifying laws that are no longer relevant and can be repealed immediately. So repealing of the old laws is also a function. Then suggesting measures for the speedy redressal of grievances of citizens in the legal domain. So suggesting forums which can speedily redress the citizens' grievances. Then recommend the enactment of new laws to implement the DPSPs and to achieve the objectives of the Constitution as formulated in the preamble. That is to suggest making some laws for the implementation of directive principles and also for the implementation of principles given in the preamble. Then give its views for eliminating delays, simplifying procedures and improving the standards of justice. So all these things can be taken up by the law commission. Then consider requests for providing research for foreign countries. So this is one unique thing and you will have to remember this for prelims, and as referred to it by the government through the law ministry. So when the law ministry refers this case, the law commission decides it on a case to case basis. Then prepare and submit reports on all issues and subjects regarding the research undertaken by commission for effective steps to be taken by either central government or the state governments. So what and all research they have made, to compile all of them and submit it as a report is also a function of law commission. So this is all about law commission. Then coming to next, the rights available only to citizens. Friends, why was it in news? Because recently in its order in Muhammad Salimullah versus Union of India, the Supreme Court rejected an application to stay the deportation of Rohingya refugees to Myanmar. Or in other words, Supreme Court gave a green signal for the government to deport the Rohingya refugees. So now key arguments for deportation, that is the Supreme Court noted the petitioners' reliance on a judgment of International Court of Justice dated on January 23, 2020, which recorded the genocidal conditions that resulted in 7.75 lakh Rohingyas being forced to take refuge in Bangladesh and India. So on the basis of the ICJ's order, the Rohingyas had approached the Supreme Court and they had pleaded against deportation. Then the Supreme Court, it relied on the word of the government that the principle of non-refoulement or forcible repatriation to a place where the refugee's life is in danger applies only to signatories to the UN Refugees Convention of 1951 or its 1967 protocol. So this non-refoulement will not be applicable to India as India is not a signatory. So that is why the deportation can be made. And this International Court of Justice's judgment, it basically is applicable only to those countries who have signed the convention, and those who do not sign the convention, they need not comply with the ICJ judgment as well. So that was what the decision of Supreme Court. And later Supreme Court also accepted that the right not to be deported flows not from the right to life and liberty under Article 21, which applies to all human beings, but from the right to reside and settle in India under Article 19 Clause 1 Subclause G, which applies only to citizens. So this right not to be deported is not a right to life under Article 21, it is the right to reside in India as per Article 19(1)G. So on the basis of that, the deportation was given the green signal. So these are the arguments and counter arguments. Then come to next. Friends, these are the lists of fundamental rights which are applicable only for the citizens. And here the trick to remember is that remember the number, that is 15, 16, 19, 29, 30. Remember this code number 15, 16, 19, 29, 30. So we know that Article 15 is prohibition of discrimination on the grounds of race, religion, class, gender, place of birth, etc. So place of birth is a matter here. So those born outside India cannot be given equal treatment with Indians. Then opportunity for public employment. Obviously foreigners cannot be given equal treatment in case of employment as well. Then freedom of association, assembly. So if we allow all these things, then it is akin to giving freedom for terrorists and anti-national activists as well. So to avoid that, even this is applicable only for citizens. Then protection of culture, language and scripts of minorities. Yes friends, here it involves substantial government funding as well. So here government doesn't have enough money to spend on foreign minorities as well. So that is why only for citizens. Then right to minorities to establish and administer educational institutions. So if we allow this to foreigners, then that can be a breeding ground for terrorist and anti-national activities. So that is why even this is amenable only for citizens. Yes friends, there are several reasons why these are applicable only for citizens, and we remember the reasons, we will not by heart. Then 15, 16, 19, 29, 30, anyway you will have to remember. Then come to next one, the Nyaya Bandhu app. Friends, why was it in news? Because the Department of Justice has launched the iOS version of Nyaya Bandhu application on the Umang platform. So on the Umang platform of Ministry of Electronics and Information Technology, this iOS version of the app was launched. Then it has been developed in the collaboration with CSC E-Governance Service India Limited. So this CSC is the Computer Service Corporation, which is an enterprise based in America, and that's branch of CSC E-Governance Service India Limited. This has collaborated with Government of India for production of this Nyaya Bandhu app, and is available in English and Hindi also. Then Department of Justice had launched Nyaya Bandhu app in 2019. So the original Nyaya Bandhu app was launched long back in 2019, and this is only the iOS version which was launched recently. Then by maintaining the database of lawyers who volunteer to give pro bono services, the department hopes to inculcate a pro bono culture in the legal domain. So overall aim of this Nyaya Bandhu program and Nyaya Bandhu app is to encourage pro bono culture among lawyers. Friends, what is pro bono legal service then? Pro bono comes from the Latin expression that is pro bono publico, means for the public good. So here lawyers are taking cases for the public good. So many lawyers provide poor and underprivileged clients with valuable legal advice and support without seeking any professional fee. So without fee, if you plead any case, that is a pro bono case, and that pro bono case, if it is done under this Nyaya Bandhu program or within this Nyaya Bandhu app, then that will be considered by the Supreme Court and the High Court during promotion of the lawyers to the post of senior advocate, and also while appointing them as the judges. So this is how the recognition is given to the pro bono cases. Then coming to more facts, the Nyaya Bandhu program. The Pro Bono Legal Service Program was launched by the Ministry of Law and Justice in April 2017. So this is in 2017, then the Nyaya Bandhu program in 2019, the iOS version in 2021. Then it would ensure that lawyers who volunteer their valuable time and service towards this public service are duly recognized for their contribution. So it is not only to encourage but also to recognize their services. This program comes into picture. Then eligible beneficiaries. Friends, who are eligible for this pro bono cases? Not every rich person can come and avail this pro bono case. Then that will be a counterproductive scheme. Then as per the section 12 of the Legal Services Authority Act 1987, this eligibility includes the member of a scheduled caste, member of a scheduled tribe, then victim of trafficking in human beings or beggar as referred to Article 23 of the Constitution, then woman or a child, then person with disability, then person in custody, that is who is already in an executive custody and is not being able to search for any lawyers, then an industrial workman, that is a laborer, then victim of mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, then person with annual income less than specified under law. Yes friends, all these people are underprivileged and they deserve something to be provided free of cost. So when the options are given, you can choose as per the backwardness and underprivileged status they are being facing right now. So this is all about the Nyaya Bandhu app. Then come to next, under trials. Friends, why was it in news? Because of the famous case, that is Kerala Union of Working Journalists versus Union of India. Friends, while dealing a petition seeking the release of Kerala journalist Siddiq Kapan, the Supreme Court held that fundamental right to life is available to under trial prisoners as well. So this fundamental right to life is applicable even to the under trials. Friends, in previous judgments, the Supreme Court has said that even to the convicts, the right to life is applicable. So friends, in that case, the judgment will not become so unique. But however, the Supreme Court's previous directives for these under trials, it becomes important. Now, the guidelines issued by Supreme Court in a landmark judgment on inhuman conditions of prisons in 2013. So that case was review of inhuman conditions in 1382 prisons versus state of Assam. So in this famous case, it gave some of the directives. So the directives are: the under trial review committee has to be set up in every district and it should meet every quarter. So there has to be an under trial review committee in every district and it has to meet 4 times in every year to decide on whether the under trials should be released or they have to be incarcerated again. Then the under trial review committee should specifically look into aspects pertaining to effective implementation of section 436 of CRPC, that is the prisoners to be released on bail except for non-bailable offences. So those under trials who are incarcerated for non-bailable cases, they can be released as per section 436 of CRPC, and that has to be looked into by this under trial review committee. Then section 436A of the CRPC, so that under trial prisoners are released at the earliest. Friends, we know that the section 436A of the CRPC says that if at all an under trial, if he has faced half of the time of imprisonment which he might have got if he is convicted, then he shall be released from the prison. So friends, for half murder 14 years imprisonment is there. So for under trial, if he is been in jail for 7 years, then he has to be released. So this is what the section 436A of CRPC says. And then the State Legal Service Authority of every state should ensure that an adequate number of competent lawyers are provided to assist the under trial prisoners. And the District Legal Services Committee should also look into the issues of release of under trial prisoners in compoundable cases. So compoundable cases means the resolvable cases. So in such cases, the under trials can be released from the imprisonment, and the District Legal Service Committee, it should look into those issues. And the State Legal Service Authority, it should provide enough number of lawyers for pleading in favor of under trials. So these are the directives given by Supreme Court. I don't know to what extent the states and districts are being implementing these. Then come to next, the government steps taken for under trials, that is establishing fast track courts to speed up the resolution of cases involving under trial prisoners. So the fast track courts have been established. And then mission mode program for delivery of justice and legal reforms. Under this, it aims to resolve 2/3 of all under trial cases and ease congestion in jails by 2010. We have already crossed 2010 and still more than 2/3 of the prisoners are under trials. We don't know to what extent it has been implemented. Then introducing the concept of plea bargaining through section 265 of CRPC. Yes, in the last class we discussed how this section 265 of CRPC works. Then insertion of section 436A. We have discussed the 436A in the last slide. Then the free legal services to be provided to all under trials by the National Legal Service Authorities legal service clinics. So these legal service clinics, they will encourage the lawyers to take up the cases of under trials, might be on the pro bono basis as well. So these are some of the steps taken by the government for under trials. Then come to next, the Article 29 and 30. Friends, why was it in news? Because Vishwa Hindu Parishad, it is demanding to amend the Article 29 and 30 so that all educational institutes would be treated equally. So this is why it becomes important. Then Supreme Court in Christian Medical College Vellore Association versus Union of India, it says that right conferred on religious and linguistic minorities is not an absolute right and is not free of regulation of the state. So this right is amenable to reasonable restrictions. Then Article 30 does not prevent the state from imposing reasonable regulations to make the administration of minority institutions transparent. So basically this Christian Medical College case, it says that the right to administer the minority educational institutes doesn't provide the right to mal-administer those institutes. So this was the famous statement given by Supreme Court. Now coming to Article 29. The Article 29 Clause 1, it says that all citizen groups that reside in India having a distinct culture, language and script. So remember CLS here, the culture, language and script. They have the right to conserve their culture and language. Then this right is absolute and there is no reasonable restrictions in the interest of general public here. So as of Constitution, no reasonable restrictions are provided, but however the judiciary can provide henceforth. So here the right is provided to conserve only the culture and languages, nothing else. Then come to next, Article 29 Clause 2. It states that the state shall not deny admission into educational institutes maintained by it or those that receive aids from it to any person based on race, religion, caste and language. This right is given to individuals and not to any community. So friends, the right is not given to any community means that the government can place reasonable restrictions on any community so that that single community will not flood any educational institute with the students of its own community. So this is how the logic goes. Then come to next, Article 30. The Article 30 Clause 1 says that all religious and linguistic minorities have right to establish and administer educational institutes of their choice. So here the linguistic and religious minorities has to be remembered. Then coming to Article 30 Clause 2, the state should not when granting aid to the educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether it is religious or linguistic minority. So friends, while giving grants, state should not discriminate for the minority educational institutes. So there are tendencies that just because they are given free to administer their institutes, the government can discriminate while granting the money. So autonomy is different, granting money is different. So this is what the Article 30 Clause 2 says. Now come to the next one, e-courts. So friends, why e-courts are important? Because the High Court of Punjab and Haryana is set to launch its first virtual court at Faridabad. So the virtual courts are going to start in India. That is why it becomes important. Now coming to e-courts project. The e-courts project was conceptualized on the basis of National Policy and Action Plan for Implementation of ICT in the Indian Judiciary 2005 mission, and this was submitted by the E-Committee of the Supreme Court. Yes, we studied this clause in the last class itself. So this is the mission, that is to bring in ICT in judiciary, and the E-Committee is working on that. Then the e-courts mission mode project is a pan-India project monitored and funded by the Department of Justice, Ministry of Law and Justice, Government of India, and it is basically for the district courts across the country. But however friends, it is for high courts as well. Here we can see high courts of India and the district courts as well. And in the website we can see various informations that are being disclosed online by the courts. So here we can see that there are 39 high court complexes. Then there are 5.88 million high court pending cases. Then there are 31.19 cases that have already been disposed. So likewise, the dissemination of information will also be given by this portal. This is the e-courts website. We can visit it whenever you are free. Now, come to more information. The project envisages the virtual courts. Yes, virtual courts is one of the main aims of this e-courts project. Then, to develop, install and implement decision support systems in the court. Yes friends, in the last class, we discussed SUPACE. So, SUPACE is the decision support system. It provides the facts related to the case and enables decision making. Then, to automate the process of information disclosure to its stakeholders. So, how to automate? This is the way to automate. So, almost all the information regarding high courts and district courts will be provided on the website. Then, to enhance judicial productivity. So, when all these are done, automatically the productivity of judiciary will increase. Then, E-Committee. The E-Committee was set up in 2004 to provide a guide map for the use of IT and administrative reforms in judiciary. So, it was set up in 2004. Then, all expenditure in connection with the function of the E-Committee is met from the sanctioned budget of the Supreme Court of India. So, what and all the money allocated for Supreme Court of India, from that same money the E-Committee will be financed. Friends, this is not a statutory committee, it is an executive board. So, that is why the members, their appointments are not so important here. Then come to next, All India Judicial Services. Friends, recently the Law Minister, he recommended giving more representation to SCs and STs in judicial service through creation of All India Judicial Services. So, in the All India Judicial Service competitive exam, if we keep reservation for SCs and STs, automatically they will get more and more recognition and representation. So, this is what the Law Minister's viewpoint was. Now, coming to All India Judicial Service, the AIJS is a proposed cadre of judicial officers to be recruited for the judiciary at the lower levels. So, below high courts, almost all the recruitments will be done as per AIJS. Then, they are to be recruited through an open competitive national level exam conducted on the lines of civil service exam. So, just like how we have IAS cadre, IPS cadre, we will be having IJS cadre in the future as well. Then, it is mooted to be an all India service under Article 312. Friends, we know that Article 312 defines an all India service, and this is included as per this all India service Article 312. Then, a National Judicial Commission will also be constituted to oversee All India Judicial Service, working on the lines of UPSC. So, just like how UPSC is for the civil services, this Judicial Commission will appoint the judicial services. Then, currently the recruitment of lower level judicial officers is conducted by the respective state governments in consonance with the state high courts. So, currently state governments and high courts, they are looking into the recruitment of lower level judges, and in some states the State Public Service Commission is doing that job. Then, coming to more facts regarding the All India Judicial Service, the history. Friends, the Article 235 puts the lower judiciary under the control of the High Court. So, as per this article, even today, the High Courts look into the cases related to appointment and promotion of lower judges. Then, the idea of formation of All India Judicial Service first came out as a proposal by the Law Commission of India in 1958. So, this is an idea that was mooted long back in 1958. Then, after Swaran Singh Committee's recommendation in 1976, Article 312 was modified to include judicial services, but it excluded anyone below the rank of the district judge. Yes, the amendment to Article 312, as per Swaran Singh Committee's recommendation, it said that yes, there should be an All India Judicial Service, but the recruitment should be for the district judges and above ranked judicial officers. So, not the lower courts. Then, the Chief Justice's Conference in 1961, 1963 and 1965 favored creation of All India Judicial Services. Then, but the proposal had to be shelved after some states and high courts opposed it, as it takes away their powers to recruit their lower level judiciary. So, states and high courts, they have opposed because it is now their prerogative to appoint these judges. Then, Government of India recently has come up with the white paper on All India Judicial Service. So, now there are chances of All India Judicial Service to be coming up, and there are talks going on that this All India Judicial Service will also cater to lower courts as well, not only the district courts and above. So, this is all about the All India Judicial Service. Then come to next topic, Master of Roster. Friends, why was it in news? Because Justice Sabyasachi Bhattacharya of Kolkata High Court issued a strongly worded order objecting to transfer of case from him to a division bench by acting Chief Justice Rajesh Bindal. So, this Rajesh Bindal, he transferred one of the cases from Sabyasachi Bhattacharya and it gave it to another bench. So, that is why he was offended and he gave a strong objection to that. Now, the meaning of Master of Roster. Friends, Master of Roster refers to the privilege of the Chief Justice to constitute a bench or the benches to hear cases. So, it is his prerogative to choose what cases should be given to which bench and who will be sitting in which bench. Then, this includes all allocation of matters before a judge as well. So, anything that is allocated to a judge will be decided by the Chief Justice. So, now in this context, there is no wrong on the part of Rajesh Bindal to take out a case from Sabyasachi Bhattacharya and give it to another division bench. Then the CJI also has the right to mark the sensitive cases to specific benches. So, if there are any sensitive cases, then that can be taken up and it can be allocated to the specific benches who are experts in dealing with these sensitive cases. Now, the issues. Friends, in 2018, this Master of Roster was a great issue and 4 judges of Supreme Court, they went to the media and aired their grievance regarding that. So, what are the arguments given there? It was that can the Chief Justice be part of a hearing of a scandal that allegedly implicates him? So, if any scam is implicating him, so can he take up the cases? So, can he become the judge of his own cause just because he is a Master of Roster? Then second, could a constitution bench be constituted by bypassing the Chief Justice in violation of the current procedure through which such benches are constituted? Friends, currently the constitution bench has to be set up only by the Chief Justice, but can any other judge, can he set up constitution bench without the notice of Chief Justice? So, in the same Prashant Medical College case, wherein the Chief Justice Deepak Mishra was implicitly implicated, in that case Justice Chamaleshwar, he went on to set up a constitution bench without giving notice to Justice Deepak Mishra. So, was this a crime on the part of Justice Chamaleshwar? So, that was discussed then. Third, this violates the basic principles of nemo judex in causa sua, or that no one should be a judge in his own cause. So, in this implicitly, Justice Deepak Mishra was acting as a judge of his own cause, and that is why other 4 senior most judges, they were offended. So, this is what the argument and counter argument was. And then come to next, the legal base of this Master of Roster. Friends, it is not present in any book, any constitution, nothing. Friends, this Master of Roster is present only in 2 books. That is, first one in the Handbook of Practice and Procedure of Supreme Court, and the second is that in the Rule 29 of the Chapter 6 called Roster Chapter in the Book Office Procedure of the Supreme Court. So, in these 2 books and in the Chapter 6 of the second book, this Master of Roster is written. Then, as per this rule, the registrar shall prepare roster under the directions of the Chief Justice of India. So, this book is basically for the registrar, and it states that registrar shall do only after the consent of the Chief Justice of India, and all such powers are subjected to general orders of Chief Justice of India. So, whatever he does, it is based on the general orders given by CJI. Then even the state of Rajasthan versus Prakash Chand, in that case Supreme Court also said that regarding the matters of High Court, the Chief Justice is the master of the roster. So not only in the Supreme Court, even in the High Courts, the Chief Justice of the High Courts will be the master of roster. So this is all about the master of roster. Then come to next topic, review petition, mercy petition and curative petition. Friends, why was it in news? Because in the famous 1 rupee case, Mr. Prashant Bhushan, he goes on to file a review petition. So now, review petition, this is under Article 137 of the Constitution, and this article says that Supreme Court has the power to review any of its judgments or orders. So hence, it gives the power for the Supreme Court to review its own judgment. Then, scope of this review petition. So it is not to take fresh stock of the case, but to correct grave errors that have resulted in miscarriage of justice. So if there are any wrong judgments, only such can be taken up. Then in a 1975 ruling, Justice Krishna Iyer said that a review petition can be accepted only when there is a glaring omission or patent mistake, or when there is a grave error in the judgment. So only these are the criteria, that is the grave errors and grave omissions. These are the criteria for the review petition to be taken up. Then come to mercy petition. A mercy petition is filed by a convict to change his or her punishment into a lesser form of punishment. Yes, we know that, friends. This mercy petition is simple one, and it is submitted to President of India or the Governor, not to the Supreme Court or the High Court. Then the scope of this mercy petition. So here only those persons can file the mercy petition whose death sentences are given by the Sessions Court and they are confirmed by the High Court. Then the convict can appeal to the Supreme Court. So here the convict had appealed to the Supreme Court, and if the Supreme Court refuses to hear the appeal or upholds the death sentence, so then a mercy petition can be submitted to President of India under Article 72 or under Article 161 to the Governor. So this is all about the mercy petition. Then come to next, special leave petition. Friends, under Article 136, the Constitution of India provides power to the Supreme Court to grant special permission or leave to an aggrieved party to appeal against an order passed by any of the lower courts or tribunals in India. So this is the permission given to appeal a judgment from the lower courts. But how this is different from normal appeals, we will see. The special leave petition need not be against a high court, unlike the normal appeals. So friends, in the normal appeals, we know that after the Sessions Court, we have to go for District Court, then for High Court and then to Supreme Court. But unlike this, in the special leave petition, we can go directly from this Session Court to the Supreme Court if the Supreme Court agrees to accept the case. So this is the difference between appeal and the special leave petition. And then it is to be used in case any substantial constitutional question of law is involved or gross injustice have been done. So only on the basis of these two cases, the special leave petition can be granted. That is, the question of law is involved or injustice has been done. Then it is a discretionary power vested in the Supreme Court of India, and the court may in its discretion refuse to grant a special leave petition. So in this special leave petition case, the Supreme Court can reject the case. But however, in a normal appeal, Supreme Court cannot reject outrightly. Then the aggrieved party cannot claim special leave to appeal under Article 136 as a right, but it is privilege vested in the Supreme Court. Yes, it is not a right of the citizen, it is only the discretion of the Supreme Court. Then special leave petition can be filed when a High Court refuses to grant the certificate of fitness for appeals to the Supreme Court. So if High Court is not allowing us to appeal to the Supreme Court and it is not giving the certificate of fitness, then we can directly go to the Supreme Court via this special leave petition. So this is all about the special leave petition. Then coming to next, the curative petition. So curative petition is a petition which requests the court to review its own decision even after a review petition is dismissed. So this comes only after the review petition. So firstly petition, then review petition and then curative petition. And friends, this curative petition came into prominence in the Nirbhaya case. So there two convicts, they filed a curative petition against the judgment. Then the procedure of a curative petition. A curative petition is supported by Article 137 of the Constitution, that is the power of the Supreme Court to review its own judgment. Then curative petition needs to be made within 30 days from the date of the judgment passed. So within 30 days of the dismissal of review petition, the curative petition has to be filed. Then a petitioner can file a curative petition only if the review petition has been dismissed. Yes, we know that. Then the curative petition is entertained if it has established that there has been a violation of principle of natural justice. So this principles of natural justice violation, this is one of the main reasons for curative petition to be accepted by the Supreme Court. Then additional grounds of considering the petition is that he or she was not heard by the court when passing the judgment. So if the petitioner feels that he or she was not heard during the trials properly, then the Supreme Court can take up the curative petition. Friends, the right to be heard is also a principle of natural justice. So nothing unique in that. Then, if the petition lacks any grounds for reasonable consideration, then the court could impose exemplary costs on the petitioner. So when the curative petition is accepted and later it was found that there is nothing substantial and it was filed only for the flimsy reasons, then in such cases an exemplary cost or fines can be imposed on the petitioner. So if you file a flimsy curative petition, then you will be fined heftily. So this is all about the curative petition. Then come to next. Friends, many of you complain that you start getting sleep when you sit in front of the books for studying. But if you are actually dedicated and determined to achieve something, then the coming sleep will go if you come and sit in front of the books. So it is that tension, it is that palpitation, it is that anxiety which is required for every student and a studier. Remember friends, Abdul Kalam has famously said, dreams are not that come when you are asleep. Dreams are those which never let you sleep. I repeat, dreams are not that come when you are asleep. Dreams are those that never let you sleep. So cultivate such seriousness and dedication towards studies and achieve the zenith in your life. Do it. All the very best. Good luck friends.